Hi, I'm Ken Fossen. Here's a question from a new administrator. I don't fully understand what authority I have to do student searches. It seems like the answer to every question is, it depends. Is there more specific guidance you can share? Well, I'll try. I think the review of two cases, one a U.S. Supreme Court case and one a Nebraska Supreme Court case, will go a long way in giving guidance regarding student searches. The U.S. Supreme Court case is New Jersey versus T.L.O. The Nebraska Supreme Court case is J.P. versus Millard Public Schools. The facts in T.L.O. were as follows. A teacher caught T.L.O. and a second girl smoking cigarettes in the restroom. The teacher took the girls to the assistant principal's office, where the second girl admitted to smoking. T.L.O., however, denied smoking and claimed she didn't smoke at all. The assistant principal then demanded T.L.O.'s purse and searched it. When opening the purse, he found a pack of cigarettes and also noticed a package of rolling papers commonly associated with the use of marijuana. After seeing the rolling papers, he proceeded to search the purse thoroughly and found some marijuana, a pipe, plastic bags, a fairly substantial amount of money, an index card containing a list of students who owed T.L.O. money, and two letters that implicated her in marijuana dealing. The assistant principal then proceeded to discipline T.L.O. and reported the matter to law enforcement authorities. The case eventually made its way to the U.S. Supreme Court based on the argument that the actions of the school violated T.L.O.'s Fourth Amendment rights. The Fourth Amendment provides as follows. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. You will note that there are two clauses. The first clause is a general provision which prohibits unreasonable searches. The second clause is a specific provision that focuses on issues related to warrants and probable cause. The second clause was politically important at the time because prior to the Revolution, the colonists had been subjected to general warrants, also known as writs of assistance, which allowed authorities to search homes without any showing of cause. In T.L.O., the court ruled that the second clause regarding search warrants and probable cause did not apply to schools. However, the first clause prohibiting unreasonable searches did. As a result, the court stated, the legality of a search of a student should depend simply on the reasonableness of the search. Okay, so what constitutes a reasonable search? The court's analysis gives us some guidance. Determining the reasonableness of any search involves a twofold inquiry. The first question is, was the search justified at its inception? The court went on to explain, under ordinary circumstances, a search of a student by a teacher or other school official will be justified at its inception when there are reasonable grounds for suspecting that the search will turn up evidence that the student has violated the law or the rules of the school. The second question is, was the search reasonably related in scope to the circumstances which justified it? The court addressed this question as follows. Such a search will be permissible in its scope when the measures adopted are reasonably related to the objectives of the search and not excessively intrusive in light of the age and sex of the student and the nature of the infraction. So, for example, if a principal searches a student's purse when a copy machine had been stolen from the office, the search would likely fail the first test because a reasonable person would not expect to find a copy machine concealed in a student's purse. Similarly, if a student was subjected to a strip search when a classmate alleged that someone stole $2 from her book bag, the search would likely fail the second test by being excessively intrusive in light of the nature of the infraction. The court went on to find that the assistant principal's search of the purse was valid. Now, when the assistant principal removed the cigarette package from the purse, he noticed the rolling papers in plain view under the cigarette pack. In light of that, was he permitted to proceed further with another search for evidence related to a drug offense? Here's the court's ruling on that matter. Our conclusion that the assistant principal's decision to open T.L.O.'s purse was reasonable brings us to the question of the further search for marijuana once the pack of cigarettes was located. The suspicion upon which the search for marijuana was founded was provided when the assistant principal observed a package of rolling papers in the purse as he removed the pack of cigarettes. The discovery of the rolling papers gave rise to a reasonable suspicion that T.L.O. was carrying marijuana as well as cigarettes in her purse. This suspicion justified further exploration of T.L.O.'s purse, which turned up more evidence of drug-related activities. So it is possible that during a valid search for evidence related to one infraction, you may see in plain view evidence related to a different infraction. If that occurs, the evidence seen in plain view will constitute reasonable suspicion to justify continuing your search for further evidence related to the second infraction. In addition to subjecting T.L.O. to school discipline measures, the assistant principal turned over the evidence to police for use in a subsequent delinquency proceeding. T.L.O. argued that the evidence should be excluded from the law enforcement action because probable cause did not exist for the search. The New Jersey Supreme Court agreed with T.L.O., but the U.S. Supreme Court did not. The U.S. Supreme Court ruled that because the school search resulting in the discovery of the evidence of marijuana dealing by T.L.O. was reasonable, the New Jersey Supreme Court's decision to exclude that evidence from T.L.O.'s juvenile delinquency proceeding on Fourth Amendment grounds was erroneous. In other words, when a school search is valid, then the evidence may be used by law enforcement in other court proceedings, even though law enforcement officials themselves may not have been able to do the search because they lacked probable cause to do so. Now let's turn our attention to the J.P. case in Nebraska. On August 18, 2010, J.P. drove his truck to Millard West High School and parked it on 176th Avenue, which runs along the school's eastern boundary. The avenue is not school district property. Later that morning, J.P. tried to leave the building with another male student, reportedly to get a book. The other student was given permission to leave the building, but J.P. was not. Not long after that, J.P. and a female student were found walking across the parking lot. When confronted by the outside security person, they said they needed to get some things from J.P.'s truck. The outside security person, probably assuming the students had permission, but also being a bit suspicious, followed them to the truck and observed J.P. getting his wallet and sweatshirt. The security person continued to observe J.P. and the other student until they re-entered the school. When the two re-entered the building, they were confronted by the inside security person and asked why they were outside. J.P. responded that the outside security person had given them permission, which was not the case. As a result, J.P. was taken to Harry Grimminger, one of the assistant principals at Millard West. After receiving the information from the security personnel and questioning J.P., Mr. Grimminger grew suspicious and had J.P. empty his pockets. Nothing out of the ordinary was found. Then Mr. Grimminger took J.P. to his truck on 176th Avenue. J.P. refused to give permission to search the vehicle, but Mr. Grimminger proceeded to do so anyway. The search resulted in the discovery of 2 drug pipes, zigzag papers, cigarettes, and lighters. As a result of the search, J.P. was given a long-term suspension for possession of drug paraphernalia. He appealed the matter all the way to the Nebraska Supreme Court. In its opinion, the court first reviewed the requirements of the T.L.O. case we just reviewed. Then it turned its attention to the issue of whether or not the school district had any authority at all to search a vehicle that was not located on school property. The court first noted that a school district is a creature of statute and possesses no other powers other than those granted by the legislature, and any action taken by a school must be through either an express or an implied power conferred by the legislature. It then goes on to find that the Student Discipline Act does in fact provide the school with implied authority to search. School officials are given no specific statutory authority to conduct searches. However, such authority is implied by the provisions of the Student Discipline Act, which grants school officials the authority to discipline students. The Student Discipline Act provides authority to discipline students when such activity occurs on school grounds, in a vehicle owned, leased, or contracted by a school being used for a school purpose, or in a vehicle being driven for a school purpose by a school employee or by his or her designee, or at school-sponsored activities or athletic events. The court then went on to find that JP's truck was not on school property, was not being used by the school for school purposes, and was not associated with a school event or activity. As a result, the district did not have authority to conduct the search of JP's truck. Therefore, the court concluded, for the reasons set forth herein, we affirm the district court's order that the suspension and offenses be expunged from JP's school record. Before leaving the JP case, however, please note that this case involved a search during the school day. If the same events had transpired during a basketball game in the evening, the result could have been just the opposite because of the language in the Student Discipline Act regarding school-sponsored activities and athletic events. Okay, let's review what we've covered and see if that will help answer our original request to provide some more specific guidance regarding student searches. Student searches are subject to the requirements of the Fourth Amendment. However, probable cause and search warrants are not required. All student searches under the Fourth Amendment must be reasonable. For a student search to be reasonable, all of the following must be met. First, school personnel must, before commencing the search, have a reasonable suspicion that the search will produce evidence that the student violated the law or a school rule. Second, the scope of the search must be reasonably related to the objectives of the search. Third, the search must not be excessively intrusive. Evidence secured in a valid search by school personnel may be forwarded and used by law enforcement in subsequent prosecutions. In Nebraska, schools have implied authority under the Student Discipline Act to conduct searches on school grounds, in school transportation, and at school activities or events. I hope this was helpful. I'd like to thank the attorneys at the Perry Law Firm for their assistance in making these presentations possible, and of course, a special thanks to you for watching. See you next week.